Have you had your deposition taken before?
Object to form.
Asked and answered, move on.
You need to answer the question.
The question was answered. Excuse me, have her read it back.
Yep.
Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not harassing
We're going to move
you.
for sanctions
I'm
against
asking
you.
you to
If you're not
answer
going
the
to
questions.
allow
He just
her-
answered the question.
And Mr. Abrams, you are represented by counsel. Your counsel is allowed to put objections on the record. You are not today.
I am a lawyer.
Do you understand that?
I am a lawyer. I don't need a lecture from you who doesn't understand the rules of evidence. If you laugh at me one more time, we're going to walk out.
We're going to move for 30D3
We're
sections.
going to move for harassment sanctions against you right now. Okay, you're laughing at us with the videotape that you published on the internet about you and your rock band, and you're going to be laughing at me.
I can't even get through my initial questions
That's
here because
your
you are being
weak-
so obstructionist.
That's
today.
because you're a weak lawyer, but go ahead. You sued me for fraud. Ask me fraud questions. You sued my firm for fraud, aiding and abetting, and conspiracy. You have no evidence. Put something in front of me and we'll answer the questions. You have nothing. You have nothing.
You have not.
We disagree.
Okay, let's ask a couple more questions. Mr. Abrams, what are the pills that you just took?
Object to
None
form.
of your business. But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
Welcome back to Legal Dissent, where no matter who you are, you have value and you have rights. I have received a ton of requests to evaluate the Johnny Depp versus Amber Heard defamation trial. And while I am toying around with making a video about that case, it isn't something I'm truly interested in covering at this point. It just shows the hypocrisy of the social elite in our society as they argue over who abused who more while in their substance-riddled stupor. Yet, we're still supposed to idolize and follow the political recommendations of the Hollywood socialites as they display their toxic natures for the world to see. The most poignant revelation that has developed from the spectacle is how very little the American public and the media understands about the rules of evidence and when objections are allowed to be utilized in court proceedings. Which brought to me another video that I've been requested to review a lot over the past year. In 2018, an attorney named Robert E. Abrams was being deposed by Tom Wurge for litigation that was pending at the time. The rules governing the examination of a witness at a deposition differs greatly from a trial. In a trial setting, there are 68 individual rules that govern the admittance of evidence per the federal rules of evidence. Generally, all objections are reserved for trial, and the more common objections like hearsay and speculation are not utilized during the deposition. The only objections that would prevent your client from having to answer a question during a deposition would be objections based upon the form of the question or if it is privileged information. Objection to form is essentially asking the attorney to clarify. It can include lack of authentication, compound questions, asked and answered, and ambiguous questioning. Both of these objections are raised very quickly in this deposition. Mr. Abrams has counsel present, but he states that Abrams is representing himself pro se, while the other attorney is representing the firm.
As you know, my name's Tom Wurge. I'm counsel for plaintiff Justin Moskowitz in this lawsuit. And do you understand why you've been asked to give your deposition today?
No.
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
And are you aware that you are a witness regarding the actions of Abrams and Associates?
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
You're sitting here today under oath. You have no idea whether you've been deposed before?
Object to form.
I've answered that question. Object to form. Move on.
Mr. Abrams, have you been deposed
Object to
before?
form.
Object to form. Move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master.
We are going off the record.
No, we're staying on the record, please.
In depositions, you have the ability to call a special master to get a live ruling on objections to enable a deposition to continue. Unfortunately, in this scenario, the special master was not available, and the parties had to trudge along without obtaining a ruling.
Mr. Abrams, I want to ask you one more time. Have you had your deposition taken before?
Object to form.
Asked and answered, move on.
You need to answer the question.
The question was answered. Excuse me, have her read it back.
Yep.
Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not harassing
We're
you.
going to move for sanctions
I'm
against
asking
you.
you to
If you're not
answer
going
the
to
questions.
allow
He just
her-
answered the question.
He did not answer the question.
He just said he did not recall. That's an answer to the question.
So it's your testimony under oath today, Mr. Abrams, that you do not recall whether or not you've ever been deposed before.
Asked and answered. And so please read
You
my
need
answer
to
back.
answer my questions, Mr. Abrams.
Please read the answer back.
No, do not read the answer back, Mr.
Like-
Abrams.
like the
This
answer
is-
to be read
Let's
back.
move on. How many times have you been named in a lawsuit in your individual capacity?
I can't recall.
Have you ever been named in a lawsuit in your individual capacity?
I think so.
Okay. And when do you think that you were added as a defendant to a lawsuit in your individual capacity?
It may have been, if I get it right, it may have been in the BB matter.
So it's your testimony today, you've been added, you were a defendant in a lawsuit in one matter, and that was the BB matter, is that
Object to
correct?
form.
I think they added me as an individual defendant, and they lost the case that went to jury trial.
You may notice that most questions asked by attorneys require yes or no answers. These are specifically crafted to paint a picture for a judge or a jury to come to their own conclusions in an easy to follow manner. You may also notice that most people hate answering yes or no questions, and they will attempt to avoid the question by elongating their answer with unasked for details. Typically, this is not a great idea, and you could add way more to the answer than what you were asked, which could open the door to additional lines of questioning that were not available until the witness started talking. Like in this case, Abrams goes on a tangent that was not induced by a question and then realizes he has said too much and objects to his own answer.
So we're going to move to strike that as irrelevant, object to form, and that it's going to lead to non-discoverable evidence. Under the rules of evidence.
Mr. Abrams, you are
Excuse me,
not
you can't
allowed
interrupt
to.
me.
I
You
am
can't-
allowed to
no,
interrupt you. This is my
he's
deposition
giving his
today,
answer.
sir.
You can't- it's
And
my
you,
answer.
it
This
is
is my
not.
answer.
You are not allowed to
He-
put objections on the record. You are a witness today. And Mr. Abrams, you are represented by counsel. Your counsel is allowed to put objections on the record. You are not today.
I am a lawyer.
Do you understand that?
I am a lawyer. I don't need a lecture from you who doesn't understand the rules of evidence. Under the rules of evidence, the only thing that can come in under the rules of evidence is truthfulness and untruthfulness. So to the extent that you're trying to disparage me because you have me on videotape and embarrass me for things that you can't bring in, I'm going to raise, move to strike, find it objectionable, and then move for sanctions for harassment under Rule 30D. You can look it up if you don't know it.
Mr. Abrams, I feel quite confident that if any sanctions are entered in this matter, it's going to be against you
Object to form.
for continuing to obstruct and not answer any of
Objection.
my questions.
Object to
You
form.
cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished.
To this point, Abrams would be allowed to object as he is representing himself pro se. Although he does have counsel present, that attorney is technically representing the firm and not Abrams himself. It's bizarre and unprofessional, but I do believe he's allowed to object to these questions even though he's the witness. Now, that doesn't necessarily make his objections effective.
If you laugh at me one more time, we're going to walk out.
We're going to move for 30D3 sections.
We're going to move for harassment sanctions against you right now. Okay, you're laughing at us with the videotape that you published on the internet about you and your rock band, and you're going to be laughing at me.
Hey baby, take a ride with me.
So, yeah, Tom Werge is the lead singer for a rock band in Colorado, and they did post some videos online. He seems to be having fun, so more power to him.
We're going to be here for a long time today if you do not answer my questions. I just want to let you know that right now
Object to form.
and put that on the record. Mr. Sullenberger,
I really like how Abrams is whispering to his attorney in the loudest voice possible.
I'm sorry.
Stop laughing at
Yes,
my lawyer.
This is bizarre.
Stop laughing at my
Bizarre.
lawyer and stop harassing us.
Listen,
You brought us
let's
down here for fraud. Ask us fraud questions.
Mr. Abrams, how many times has your firm been added as a defendant in any lawsuit?
As I can recall, one in the BB matter.
So the BB matter and then this matter as well? Those are the only 2 times you recall that your firm has been added as a defendant?
Yes, as I recall.
Aside from traffic tickets, have you ever been named in a criminal action?
object to form.
Object to form and privilege, so I assert privilege and need not answer.
What privilege are you asserting, sir?
Attorney-client privilege, and we would, under the law, I need not answer that.
What law are you referring to, Mr. Abrams?
I need a law book.
This is a bogus objection for privilege in this instance. Attorney-client privilege protects the conversations between an attorney and their client. Arrest records and other public information would not be subject to this kind of privileged information. There might be a very few limited exceptions to this, but the possibility of that is extremely slim.
What privilege are you asserting today, Mr. Sullenberger?
Attorney-client privilege. He's already answered the question.
So Mr. Abrams is saying he has an attorney-client privilege over himself being named as a criminal defendant.
Yes.
And the question's intended to harass and annoy. And under 30D3, again, we're going to move for sanctions for repeated conduct like this.
I can't even get through my initial questions here
That's
because
your
you are being
weak-
so obstructionist
That's
today.
because you're a weak lawyer, but go ahead. You sued me for fraud. Ask me fraud questions. You sued my firm for fraud, aiding and abetting, and conspiracy. You have no evidence. Put something in front of me and we'll answer the questions. You have nothing. You have nothing.
Mr.
Put
Abrams,
something in
are
front
you
of me.
aware that Judge Starrs already ruled that there is substantial evidence against your firm that you committed fraud?
Object to form.
For misrepresentation of the
Are you
evidence,
aware?
Mischaracterization. The fact that the judge let you bring your bogus claim against us doesn't mean that it's merit full. Do you have a fraud question for me?
Please answer the question.
He just
again.
did. Ask
I
and
did.
answer.
Are you
We're
aware?
Yes, I'm aware. Move on.
Mr. Abrams, have you ever been arrested?
Object to form and privilege, attorney-client.
That's it.
And you're instructing your client not to answer that question on the basis of attorney-client privilege, Mr. Sullenberger.
It's my understanding that Mr. Abrams had an attorney for any issues that may have arisen, and therefore he can assert.
I also don't recall being
What,
arrested.
what part of my question asked for any attorney-client privilege?
He's not being
communications?
deposed.
I don't have to. I
We're
objected.
not
I
even
objected to
asking
form.
questions.
I objected for privilege for Mr. Abrams.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
Fine.
It's clear that you are not here to answer any questions
clear that
today,
you're harassing
and
us.
you are refusing to answer
We've
any of the
answered
questions
every
today.
question, read every question
Yeah,
back.
you have not.
We disagree.
Okay, let's ask a couple more questions. Mr. Abrams, what are the pills that you just took? during this
Object to
deposition?
None of
form.
your business. None of
Privilege.
None of
What
your
are those?
business.
What are those other
None of
pills?
your
Object to form.
of your business.
Object to privilege.
None of your business.
Medical privilege. Don't
Mr.
answer.
Abrams, are you under any any drugs today? Have you taken any drugs before you came to this deposition today?
No.
Okay. Have you taken any alcohol before you came to this deposition today?
No.
Any medication whatsoever?
No.
No. Just these pills that you're taking here.
Yes.
That you are refusing to answer what they are.
Yes,
Medical
but none of your
privilege.
business.
Okay.
It is a very common question to ask a deponent if they are under the influence of drugs or alcohol during a deposition. It is very uncommon for a deponent to be slinging pills like candy during a deposition. Medical privilege is a limited privilege that is reserved to medical care providers in regard to their patient's care. It would not necessarily apply in this situation.
But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
Oh, you're referring to when you called me fat when you walked in here.
Objective
right?
form.
You don't recall that? Okay. Well, we have a couple of witnesses to that, including Mr. Sullenberger. In any event,
If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
Calling your opposition fat in a deposition is a strange tactic to take and is not going to be viewed favorably by a judge. This is unprofessional behavior, especially accompanied with the continued chugging of these unidentified pills that Abrams keeps taking.
are you here today pursuant to the subpoena?
Yes.
Okay. So your subpoena didn't get quashed, did it?
Yes, it did.
Sure didn't.
Yes, it did. Argumentative. Move on. What are you
Okay,
laughing at? Why do you keep laughing? What is it with you? Why don't you look at the camera and laugh at them?
Mr. Abrams,
Your
testimony is being taken
Just
today.
ask me some questions about fraud, civil conspiracy, and what other trumped up things you did under your license that we're moving for sanctions against you. Do you realize we sued you for abuse of your law license? Do you realize that? And that we're going to continue to sue you for the way that you've been treating in this matter? You have no evidence. If you do, show the jury, put it in front of us, we'll ask questions. You haven't put one document in front of us. Open something up and make this a meaningful deposition or let me go.
In that motion, you included that Mr. Abrams' anxiety requires him to take medication on extended flights that impairs Mr. Abrams' facilities. Can you please explain what medication you were referring to in your filing?
Objective form
No.
medical privilege.
Privilege.
Medical privilege.
Yes. Move on.
What privilege is that?
None of your
Absolutely
business.
no right.
No, what medicine I take is none of your business. Move on.
You filed a motion with the special master saying that because of a certain medication that
Yep.
you could not sit for your deposition.
Yes, that medicine's none of your business. Move on.
And now
Objection,
you've
privilege.
come into this deposition today with a handful of pills
Yep.
that you refuse to answer questions about
Yes,
what they are.
None of your business. HIPAA protection privilege. Move on.
We will
until he
continue
does.
all three of the
We will
depositions
move
that
to
are scheduled
strike.
for today because it is very clear that Mr. Abrams, Mr. Sullenberger, and their firm intend to obstruct discovery in this matter and do not intend to answer the questions today. We will ask that it be reconvened before the special master with Abrams and Associates to pay the full amounts of everything associated with the depositions, including the special master's fee. And we will be filing a motion to take that up with the special master today.
We disagree. We're filing the exact same motion and seeking the exact same sanctions. Anything else?
We will continue the deposition and go off the record at this time.
In a disciplinary decision, Abrams was suspended for a year, but he only had to serve 90 days of that suspension as long as he completed a 2-year probationary period. He was suspended not only for his behavior in that deposition, but also for other misconduct, which included using a homosexual slur when referring to a judge. When confronted about his use of the word, his response was that it was just a reference to the judge as a weakling who probably got beat up in high school, and that the judge didn't like him because he reminded the judge of bullies who beat him up. According to Abrams, the whole thing is just obnoxiously political correctness. In the end, Abrams is back practicing law in Colorado. What do you think? Is the legal system too formal and politically correct? Or is civil discourse a necessary requirement to ensuring that people have their day in court? Let us know in the comments below. And remember that no matter who you are, you have value and you have rights. Do not be afraid to use them, and we'll see you next time right here on Legal Dissent.